the Chapter 13 trustee is not your friend. They're your opponent. I think the biggest mistake that I see in Chapter 13 bankruptcy cases is not having a realistic budget. So often, the Chapter 13 process is long and confusing. You have to make the full and fair disclosure of assets and debts, income, expenses, financial history. It feels like it's a ton of documents that your lawyer's asking for. And then the budget is really the last thing we work on. And so often, we don't put as much focus or attention there as we need to. And so I think one of the biggest mistakes you can make in a Chapter 13 is not having a realistic budget. We are committing you to a 3 to 5 year legal process under which you are going to make payments to the trustee for all of those months. And if we don't set up a budget from the beginning that's workable for you, that takes into account the actual things your family needs to spend money on, or if you're spending money on things that are not something we can put into the budget, we need to make adjustments for those ahead of time. So I think as you're looking at a Chapter 13 plan and getting ready for a Chapter 13 bankruptcy, you need to make sure you understand what's in your budget. This could include everything from the basics, your food, expenses, your utilities, household goods, but also things that don't come up every month. We all pay an electric bill every month. We all pay mortgage or rent every month. But the things that don't come up every month and tend to come in fits and spurts, like car repair, physical maintenance, I call it, which is really just doctor's visits, dentist appointments, getting eyeglasses, your children's extracurricular activities or their school expenses. In the summer, you often have camp for your kids that costs much more than after-school care does during the year. If you live in a place where it's cold in the winter, your electric bill goes up significantly. Or if it's a hot spot, you're going to be paying more for your electricity for air conditioning. These are variations that you need to keep in mind because if you don't, your budget's not going to work and you're going to have difficulty making that plan payment, and that's going to lead to failure of your Chapter 13 plan. So I can't stress enough how important that budget is from the beginning. Not making your Chapter 13 plan payment. It seems basic, right? The whole purpose of this is to make the plan payment and get your discharge at the end. Often in a Chapter 13, you're there to cure a mortgage or to pay back taxes or child support arrears. Making that payment is critical. What I see happen is that over time, that payment becomes less of a priority, or maybe you're a little short this month, so you just don't make it, and you think you'll make it up next time. Each time you miss a plan payment, it puts you further behind and it makes it more difficult to be successful in the plan. That goes double for your mortgage payment. One of the most common reasons we put a client into Chapter 13 is to cure arrears on a mortgage. The key is that you have to continue making that mortgage payment going forward. So we're going to catch up that mortgage in the plan. You either will make your plan payment with the mortgage payment to the trustee, or you're going to make your plan payment to the trustee and the mortgage will go directly to your lender. If you don't make that payment, either to the trustee or to the lender, you're going to lose the Chapter 13 protection and you're not going to be successful in the plan. Have solid communication with your lawyer. From the very first time that you hire them all the way through to the end of the plan, you should be in touch with your attorney when anything changes. If you're about to miss a plan payment, the best thing to do is to reach out to your lawyer. They're the ones who can help come up with strategies and solutions to help you get that payment made or to modify your plan so that you don't miss the payment. If you've lost your job, if you need to buy a car, a lot of things happen in our life over a 3 to 5 year period. And we do not expect that 3 to 5 years is something you should do all alone. If you have a new job, if someone gets sick, if you lose a job, if your car blows up, if your air conditioning goes out, we need to hear about that as your lawyer. So give us a call. I'm always telling my clients, I'm here for you from the first moment we file the case until we file that last document. The next mistake that I see a lot of people make is to incur new debt when you're in Chapter 13. I don't mean running out and grabbing a credit card as soon as the case is confirmed, which I certainly don't recommend, but I mean bigger debt. Let's say your car breaks down and you need to do a significant repair, or you need to replace it. In many districts, you need permission from the Chapter 13 trustee in order to do that. Instead of going out and financing a vehicle without trustee permission and having that become an issue in your case later, reach out to your lawyer, give us a call, and let us help you do an application to incur new debt. With regard to that credit card I mentioned a few minutes ago, we want to be careful about incurring new unsecured debt. I advise clients that I can't include payments on those debts in your budget for a Chapter 13 plan. We're committing in a Chapter 13 case to repaying creditors that you had before we filed. I can't allocate money in your budget to paying creditors that you've incurred debt with after we file, unless we have permission from the trustee. So if you find yourself during the course of a Chapter 13 plan needing new credit, please feel free to reach out to your lawyer so they can give you good advice on what the process in your district is. Talking directly to the Chapter 13 trustee's office. I tell my clients the Chapter 13 trustee is not your friend. They're your opponent. If you have anything that you need with regard to your case, if you need to know whether your payment is changing, if you've made a payment, if you can incur new debt for a vehicle purchase, you should talk to your lawyer. Don't talk to the Chapter 13 trustee. Their job is to enforce the rights of the creditors, to collect money from you and use it to pay your debts. They are not there to be your friend. So don't call the Chapter 13 trustee. Call your lawyer and talk to us about your case. That's what you're paying us for. Throughout the course of your Chapter 13 case, you're going to have some obligations that have to be completed. Before we file, we're going to request a whole bunch of documents and information from you, but that is not the end of the obligation for you. You must show up for your meeting of creditors. The meeting of creditors takes place approximately 30 days after your case is filed, and it's an opportunity for the Chapter 13 trustee to have a conversation with you about the content of your petition. Their job is to verify that the information you've provided is true, accurate, and complete. Their job is to review the Chapter 13 plan that you and your lawyer have proposed and ask questions about the contents of it. They may ask you if you're current on filing your tax returns. They'll ask you whether you have paid any friends or family members in advance of the filing of the case. And they may ask specifics about your mortgage, how you got behind, whether you're going to keep a vehicle or other secured property, and in general, review all of the elements of your case. This meeting is mandatory. If you don't show up to your meeting of creditors, that is a big red flag and your case will get dismissed. Your lawyer will give you information about when that meeting is scheduled to take place. And in the United States, every single meeting of creditors is conducted by Zoom. In most districts, these meetings are scheduled about 4 or 5 every half hour. That gives the trustee between 6 and 8 minutes per case to have a conversation with you and clarify the information I outlined before. 6 to 8 minutes out of your day, and the meeting of creditors is over. It's a mandatory step that you have to complete, so be sure that you attend that meeting. Another one of the mandatory requirements in a bankruptcy Chapter 13 case is to complete your financial education course. Before you file a bankruptcy, you have to file your credit counseling. You have to complete your credit counseling course. The financial education course is completed after you file. Some attorneys will have you complete it as soon as your meeting of creditors is over. Others will wait until the very end of your case. As long as you get that certificate filed, you're in great shape. If you fail to file that certificate, the court cannot enter your discharge. That's the formal notice to creditors that you don't owe them any more money. You need that piece of paper. That's the whole goal of our Chapter 13 process. It's also critical that you ensure you've made all the plan payments, but that you've also stayed in touch with your mortgage lender. If you're curing mortgage arrears, you want to keep track of each payment that you make. There are special rules in the bankruptcy court that give us the ability to challenge certain fees and charges that a lender may bring, and we want to make sure that we have a good record. So keep good records of each payment that you've made. Talking about some other things that you want to make sure you don't do in a Chapter 13 case. Don't transfer money or property to friends or family members during the course of the case. Don't give away property. Don't hide property. I think the biggest challenge that we see in Chapter 13 cases is not getting all the creditors listed. We have a little more flexibility in Chapter 7 cases, especially no asset Chapter 7 cases. If we don't list every creditor, sometimes they're still discharged. Because you're making a monthly payment to pay creditors in a 13, any creditor who is not given formal notice of the case and an opportunity to file a claim is not discharged, which means you still owe that debt after paying for 3 to 5 years. Make sure before you file that every medical bill you owe, every payday loan, every Affirm buy now, pay later account, every credit card, every collection agency, every friend or family that you might owe money to is listed in your petition and notice is given to them. If you don't give notice to any particular creditor, that creditor is not going to be discharged.